Well, these two matters were supposed to
Which
come
one? Which
today, but these are appearing as item number 381 and 353. These are pertaining to, my lord, the ongoing recruitment process of the West Bengal Board of Primary Education, my lord. We are covered by the Honorable Supreme Court's judgment, my lord.
Which judgment?
My lord?
Which judgment?
My lord, that Kaushik Das judgment, which says that 18 months DLED, they are, lordship, entitled to participate as well as for everything in service benefit they can get, lordship. So, lordship, this matter
81 and
381 and 353, my lord.
same.
353 is for age relaxation on the same ground.
353.
My lord, these two matters, my lord.
এটাই হ্যাঁ 353টা তো রিচ করবে না, ওনাকে তুমি টিউসডেতে টপে একটা মিসলেনিয়াস হিয়ারিং করে রেখে দিন। মঙ্গলবার দেখে নিন যে কোনো অন্য ম্যাটার আছে কিনা, শুধু ওই ম্যাটারটাই হবে।
একটু দেখে 381 and 353.
One is Nita Ghosh.
One is Nita Ghosh, another is Sankarshan Barma.
On Tuesday. ওটা নিয়ে নাও।
But I have similar prayer. Item number 349-403. Last week the matter appeared as item number 9 under miscellaneous hearing. Now, my lord, this matter, my lord, regarding matter pertaining to the new recruitment process of 2025 initiated by the West Bengal Board. My lord, my contention is regarding, my lord, marks normalization and item that was item number 9. I was under the impression that it will be today, my lord, it will be at serial number 2 and 3.
What to do? There are other matters also, no?
Yes.
All the miscellaneous matters, 50% of them are in relation to the recruitment process.
No,
You have to go serially. 24
my matter is exceptional because, my lord, we challenge the, my lord, marks normalization and the privilege, my lord, given, my lord, marks in the DLED on the basis of academic qualification to the candidate who passed the pre-2010 batch and post-2010 batch in the higher secondary education.
What is your item?
349 and 403. Two matter. 349 and 403. ইসটাও লিখে দাওনি, তোমাদের কি বলবো?
Who is for the board?
ওই তো
349 and 403 are same.
Yes, same.
These issues are not urgent.
This issue is urgent because the last date of filling up form was by 9 December.
This issue, my lord, kindly see the repetition. But it's before, my lord, 2022 recruitment process.
This issue before 22. I have a notification.
No, we will hear it later on then. If it is not relevant to the present recruitment, we are not
relevant to the present recruitment process.
If it is 2022 recruitment process, then don't mention.
My lord, kindly bring the file then. Kindly see, my lord, the new recruitment process.
It is possible. Bring the file and go through the file and find out whether it is 2022 or
2025. The
2025.
new recruitment process. Why then I will not submit that.
If it is related to the present recruitment
process, my lord.
So why they are saying so?
Let them prove that is the earlier recruitment process.
Your lordship running as item number 14. Your lordship CD, my lord, repetition, my lord, yes.
Item number
2. Item number 40. Just only CD, my lord, repetition, my lord, yes. The same issue, my lord, there, my lord, item 14.
2022.
তোমাদেরও তো আছে ম্যাডাম
Repetition 2022.
Then
hello, where
I tell you, this is
I don't know.
but this is a bad time, lad, Mr.
Oh, you have
Judges.
come.
Yeah, for other matters also.
Mr.
I have very
Ask your junior to go through the records.
I'm extremely sorry, lad.
Believe that all are existing.
I
I have posted it to be mentioned and found that 9 of the items are dismissed for default.
Possibly 6 or 9.
6.
9. my lord, we have taken out an application for restoration that was not placed. This is our mistake, my lord. Application for restoration was
But may I permit to mention item
Well,
411?
349 and 403, let it be taken up any day, my lord. Tuesday, my lord.
Tuesday, madam, Mr. Sandal.
Another matter, my lord, Mr. Shobhoshaji Chatterjee also mentioned regarding the new recruitment process. My matter is also similar.
in this matter, my lord, Mr. Chatterjee is mentioning.
Yes.
In this matter also, the issue is that for any selection process, my lord, this is relevant because we are seeking that the marks distribution system. My lord, we have challenged, my lord, that those who have
Sir,
passed
You
prior
have to take into consideration the extent of your eligibility in the coming recruitment process.
this is one
If
part.
you have raised any issue which is pending before this court since long and now it has to be decided since there is a recruitment notification, then I fail to understand.
No, I filed the new writ petition on the basis of
Cause of action is pertaining, goes back to 2022 when this matter has been order has been passed by the single judge. Then you go to the division bench, there is a order, formation of a committee, normalization.
committee
All
filed the
this cannot
report.
be decided in 1 or 2 days. It
Madam,
needs a thorough hearing.
Thorough hearing is
Hearing.
required. That's
But-
kindly
but
post it.
the matter is not taken up.
After vacation, post
এর মধ্যে তো ওরা proceed
No.
করে দিচ্ছে।
Yes.
My lord, may I permit to mention item 411, my lord?
hearing and করতে পারবো।
My lord, the 25th December is the last date of submitting application for my lord, the pursuing, my lord, 6 months breach course, my lord, in connection with the primary teachers who are having the B.Ed course, my lord, as per the direction of the Honorable Supreme Court, my lord. Now the medium of language, my lord, instruction has been restricted to the English and Hindi, my lord, which is hit by, my lord, the 8th schedule of the Constitution, which recognize 22 other languages, my lord.
What do you want?
My lord, for upgradation, my lord, 25th December is the last date, my lord. I had mentioned it
For admission.
ছুটির আগে
for admission, for submitting application for pursuing 6 months, my lord, the breach course, my lord, in connection with B.Ed course, my lord.
Your item number is?
411, my lord.
So you want to appear in which language?
My lord, the Bengali, my lord. Since, my lord, in terms of section 29F, my lord, the medium of instruction should be
16 তারিখে ওটার পরে এটাকে please করুন।
my lord, I am mentioning for inclusion upon notice, my lord. My lord,
Who's for the court?
Lord, I am mentioning for inclusion in your lordship's list, my lord. My lord, I am covered by your lordship order, my lord. This is regarding the pursuing DLED candidates for
When did you file the application?
my lord, very same date when your lordship passed the order, my lord. My lord,
When did I pass the order?
it was filed on 3rd of December. It's not
Over.
running in the list. That's why I'm mentioning. My lord, only one thing, my lord. I'm fully covered by your lordship.
After 2nd December, no, it cannot be entertained. Yes.
My lord, let it be.
I-
Let it appear in the list. Let it be
can
decided.
Yes.
I must say sorry, my lord. It's my mistake, my lord. Though the applications are appearing in the list, my lord, we did not place it, my lord. I talked to Mr. Arjun, my lord. At least one line order is required to restore the matter. Otherwise, this order cannot be passed directly. Can it be these applications be taken up to mention any time? Is it possible?
No, we will
Otherwise,
place these applications under the heading applications. This will go
as you
on the
lordship
same
pleases,
date.
as you
On the
lordship pleases.
same date.
On the same date.
The other matters will appear under the heading hearing, and these matters will go under
Only
the
one more thing, my lord, indulgence and seeking, my lord. I have checked, my lord, some applications are missing from the record. We have the copy with us. If you permit us, my lord, to file our copy from us, my lord, for reconstruction,
Which one are those?
my lord, we can, my lord, point out.
Then do
My lord,
one
I
thing.
shall point
You-
out and my lord,
Yes. On which date this is coming up?
my lord, after vacation you have posted
21st.
21st.
of February, my lord. 21st of February. So
But any
you
day
find
before-
out on that day you indicate, if possible, you reaffirm the same contents and file a copy of that
That we
by
can.
reaffirmation.
That we can do. But so far, my lord, these applications are concerned, my lord, can it be taken up prior to that 21st? Oh, 21st January. Oh, then it's fine. Then it's fine.
You have to start.
I'm sorry, man. I'm extremely sorry, man,
Yes.
for the mistake.
Lordship, may I permit to mention one matter? Lordship, I have mentioned this matter on 8th December, but your Lordship was directed to list this matter on today's list, but the matter is not appearing on today's list, Lordship. File এখানেই আছে।
রাখুন।
Notice serve হয়ে গেছে।
কপিটা কোথায়? Where is the copy of the notice?
Lordship, I have already submitted on prior. Great.
Copy.
Lordship.
But I'm for the
the petitioner, my lord. This is the petitioner is a TET qualified candidate, my lord.
Which year?
I'll just show. I will kindly come to page 24, my lord.
Which year?
Page 24, my lord has got it.
Yes.
And this is the roll number of the petitioner. The petitioner's name is there. It is specifically stated you are included in the present merit list. And this is from the website of the respondent
2014.
concerned, my lord.
2014.
My lord.
You appeared as an untrained candidate.
My lord, this is the TET qualification. I am a trained candidate. It is not that I am an untrained
So
candidate.
what is the difficulty now? TET 2014 qualification is there.
That qualification is there, but the only thing, the successful certificate, although the screenshot is there which says that I am in the merit list, but the TET successful certificate was not given. So I had approached this honorable court. This is the second round of litigation. I'll just show the first order, my lord. The first order is at page 35.
Supply a particular certificate.
Page 35, my lord. The order says the petitioner had participated in
Yes,
TET
yes.
2014. My lord will kindly come to the third paragraph. The petitioner is directed to supply her particulars to Mr. Bishas, my learned friend who was representing the concerned respondent. And the board is directed to take steps for issuance of such certificate to the petitioner as expeditiously as possible. This is the order.
Yes.
And the petition was disposed of. My lord will kindly turn over to the next page. I had communicated my learned friend.
Then what happened? Certificate has not been issued.
Certificate has not been issued. Page 37, I've given all my particulars and no further particulars were even demanded. Along with the order and everything, my lord, I had even written to my learned friend's client, that is at page 56. Even thereafter, certificate not given, my lord. I'll be relying on a supplementary affidavit to show the urgency right now. I'll be subject to leave of my lordship.
Primary teacher. Yes.
Yeah, may I file a supplementary affidavit to show the urgency? Why is it so urgent right now? I will kindly come to page 4 of the supplementary affidavit. And my lord has found it. Page 4, my lord.
11 September 2025.
Malad, your lordship, Malad, need not travel to Malad all these things. Malad, state your lordship, kindly come to page 24. What my learned friend is relying that he has passed state. Malad, this is a forged document. Malad, I request your lordship, Malad, I am paying before your lordship. Malad, your lordship kindly send it to the Malad, the authority, Malad, the police. Malad, to verify and Malad taking into custody and Malad the interrogation. Malad.
An order passed. An order passed. No recalling application
Malad,
filed.
he is asking for the TET certificate. He has not passed TET even, Malad. How is desperate, Malad?
How desperate. Now there's an order passed by this honorable court that has not been complied with. No recalling filed, no jobbing filed.
I'm asking myself, said, Malad, that if he has not passed the TET, you have issued the certificate.
That should have been communicated. No communication. Right now, when I come before
Malad,
this
we
court,
have
this is the
issued
first
the TET
time
certificate
that
as
this
per our
assertion
database.
is being made.
Malad, the document is absolutely a forged document. This is not the document of the board at all.
First time. This is the first time this
Malad,
assertion
what
is
first
being
time,
made.
Malad, those who have passed
First
the
time.
TET, my lord, their names are appearing in the website for last 2-3 years. My learned friend, can my learned friend show before your lordship that his name is appearing in the my lord website, official website of the board, that he has passed it?
That was not appearing. That is why I approached this honorable court on the earlier occasion. And
But
my
he
learned
knew
friend's
that he
client
had
did not
not
object to that.
passed it.
Did not take that point. Now, when the recruitment process starts off, this point of forging kindly comes.
My lord,
Suddenly appears.
the bottom
out
of the
blue.
page 24, my lord, kindly read. You are included in the present merit list.
What does
Well,
that mean?
these type of documents we never issued by the board. Never
This
issued.
was not taken in the
Well, this
earlier
is not
round
the
of
first time
litigation.
before this honorable court. This type of documents also, my lord, with the coordinate bench. This was referred to, my lord, the appropriate, my lord, the police station. My lord, the petitioner was arrested. My lord, he was taken into custody. My lord, interrogation. My lord, charge sheet was filed. My lord, the another, my lord, 2-3 matters. My lord, I know, my lord,
In
I
my
also
case, this
appear.
has not been done. In my case,
My lord, now it will be done.
my case, this was not been done, and this was with
Now,
the
if it is found that it is not genuine, then steps will be taken. There is a report.
will be ready to
report.
face the consequences.
But
File a report to this effect that this is not genuine.
Monday, my lord, Tuesday, I will file it.
The only thing, my lord, will kindly note that this was not a point taken in the earlier round of litigation.
Not
If it is not
required, my
taken,
lord.
then you will base your basis on the
No,
basis
no,
of
no,
forged
no.
document.
I will not, and this is not a.
Court has directed for taking steps.
That this was not taken in the earlier round of litigation. Well, this is well settled. Fraud vitiates everything.
Yes, fraud vitiates
Therefore,
everything.
my learned friend cannot take on the plea the earlier round of litigation. This was not taken. If the document is forged, this is the fraud on his part. And
There
fraud
has
the
to be
honorable court.
conclusively
That's
proof
different
that
thing.
this is
That's
forged.
different argument. My learned, I'm dealing with the argument that this was not taken by my learned friend in the earlier round. That doesn't absolve my learned friend.
Does
It's a
not.
fraud.
Does not. But today an argument which was not
It says
being taken right now at the time of
affidavit
recruitment
filed on
process.
behalf of the petitioner, on the prayer of learned advocate for the petition, leave is granted to file supplementary affidavit. Supplementary affidavit, copy given?
Yes, the copy I've supplied.
Supplementary affidavit filed on behalf of the petitioner is taken on record, copy served. Mr. Shaunak Ghosh, learned advocate for the petitioner, submits that the board has till date not issued certificate which was directed in earlier round of litigation in WPA 4923 of 2025. Though the website of the board shows that the petitioner has been included in the merit list.
May I have your lordship sign leave?
Annexure P3. What?
May I have your lordship's kind leave? May I go to another court if your lordship permits?
I couldn't.
If your lordship permits, another matter.
You want to?
Another matter has been taken up in court for
Yes,
your lordship. May I have your lordship?
Mr. On the contrary, Mr. Ratul Vishwas, learned advocate for WBPPE, West Bengal, okay, submits that the document, namely Annexure P3, is a forged document. He seeks to file a report on the returnable date. Let such report be filed by the board, respondent board, on the returnable date. Okay. ওই 16 তারিখে একটা রাখুন নাকি ছড়িয়ে দিই একটু 17th করে দিই 17th করে দিই 17th
17th, your lord.
Only my humble request, if it can be taken up fairly at the top, man. That is my only humble request, because
17th. Yes, my lord. No issue. I'll
17th
come by, my lord. On oath, my lord, I will file this.
on the at least on the same heading, if it can be
ওটাকে
recorded.
এ করে দিন report in the form of affidavit.
Yes.
Well, I am appearing for this.
It's mine.
I do not have any.
Nick.
না তোমার রোল আছে ইনভেস্টিগেশনটা
Yes, well, I have the report in the form.
বই এসছে আমরা বই এনেছি
But petitioner, there are 30 candidates, those who are petitioner with your lordships today,
30
are having, my lord, the B.Ed qualification and, my lord, TET qualified
of
and, my lord,
of which year?
B.Ed, my lord, and different years. My lord.
Date of which year?
I tell you, lordship, petition number 1 passed out B.Ed in 2015.
Not B.Ed. TET.
B.Ed,
TET of which year?
TET, my lord, 2014.
14.
So one state, my lord, as per NCT guideline, one state qualified, it is valid for lifelong. So as your lordship knows, my lord, in many occasions, the lordship was pleased to hear these things. Now, my lord, the subject matter is very short and prayer is also very innocuous. Now, the petitioners are having B.Ed qualifications, B.Ed degree, state qualified, and 6 months bridge course, which is, my lord, known as the name of the bridge course is, my lord, Professional Development Program for Elementary Teachers, in short PDPET. There are two kinds of bridge course introduced by NCT, those who are academic body of India. One is PDPET, another is DLED. These are two training qualifications.
Okay.
It is applicable for whom, my lord?
কাগজ
It is applicable for whom? Well, it is applicable those candidates, those who are in-service teacher, primary teachers.
PDPET.
PDPET and DLED. The two types of 6-month bridge course had been
No,
introduced
PDPET is for in-service or normal candidates?
for normal and in-service both,
Okay.
as per NCT guideline 2017. I shall place the guideline also. Just a minute. Better to not place this guideline. This is one of the guidelines introduced by NCT. NIOS was appointed to conduct this 6-month bridge course. Those who are in-service teachers, primary teachers.
No, who are in service?
Alright.
Who are in service of the
All
petitioners?
the in private primary
All the
schools,
candidates,
not in government or aided. We have been working in a private primary schools. We didn't get the job.
জব তো পেয়েছিস
Private, sorry, private.
আর প্রাইভেট থেকে জব না
Now we are seeking government.
সেটা অ্যাডভান্টেজ নিচ্ছ ইন সার্ভিস বলেছিল
Now, my lord, the disputes regard to, my lord, this is mere apprehension that as per so far the new recruitment policy and the notification which has been made and published by the board, but on my lord, on 19 November 2025, but which has, as your lordship knows, expired, my lord, on 9th, but we would not be allowed to participate in the selection process. Today, my lord, before your lordship, my lord, I am not seeking any employment or any appointment. My lord, only praying before your lordship, my lord, very innocuous here, to permit us to participate in the ongoing selection process. In view of the Supreme Court, my lord, order, an observation made on 21st November 2025. In a similarly placed manner, my lord, but all the candidates from different high courts, my lord, they went to Supreme Court. Our cause is also pending before the Honorable Division Bench for recognitions of PDPET, whether PDPET is a valid qualifications or not. That the subject matter is also pending before this Honorable Court. These are the petitioner also party to those that appeal. It is in appeal. It's a intra-court appeal is pending, and another set of litigations are pending before the Honorable Supreme Court. But kindly come to only one annexure, page 50. That is the Supreme Court's order passed on. This order, interrogatory order, passed on 21st November 2025 in connection with those SLPs. There is a transfer petitions and main SLP is pending. From every state, various transfer petition was made to join in that SLP. So we are, although we are not the party to that SLP, but our cause is pending before this Honorable Court, like other high courts. Only kindly come to page 50 on the order passed by Supreme Court. May I read out this order of the Supreme Court?
No, I've seen that order.
Only thing, our right accrues from the date of the passing of this order of the Honorable Supreme Court.
No.
The only thing, can you direct the board to allow us to participate in the selection? Nothing more. But this is my humble submission, and they can't disown that this PD paid is not the valid qualification because Your Lordship kindly see the last annexures. That is, we made petitioner number 1, made an applications under RTI Act, where board itself has given reply that yes, PD paid 6 months bridge course is equivalent to DLED 6 months.
Where is that?
Page 54.
Page 54, query.
Page 55 is my query.
Chairman,
Query number 1 is the NIOS bridge course PD paid along with B.Ed is equivalent to 2 years DLED degree. Answer was given by NCT, the academic body, page 56. Point number 1. And point number 1, point number 4, and question number 2. A copy of the order dated 22nd September 2017, as I placed before your Lordship just now, is enclosed herewith, which is self-explanatory. Answer was yes. So it is admitted fact the academic authority, those who had introduced this PD paid bridge course, said that it is equivalent. Both the bridge course 6 months bridge course is equivalent. PD paid is equivalent to 2 years of DLED. Although there are 6 months also another DLED course is there, that is also known as bridge course for 6 months. It was also introduced by NCT, and NIOS was directed to conduct this bridge course. So I'm not taking on that point. I'm not going to that extent. But only thing, since we are similarly placed, the candidates, those who are before the Supreme Court said allow them. These are the answer given to the RTI applications by the academic body, which is binding upon board also. It has not been challenged by anybody.
সিস্টেমটাকে ডিস্টার্ব করার চেষ্টা।
yes.
And page 53 of my petition, this is the documents from letter written by the principal secretary of the state, who recognized, the state recognized our 6 months bridge course.
Which one?
Page 53 of my petition. Annexure P3. This is the
No,
letter.
which portion of this recognition order says that PDPPT is a recognized
The NCT said so.
which clause?
Kindly come to me.
এটা কাম টু কোথায় হবে? পিটিশনে নেই।
Paragraph of this notifications. Notification dated 22nd September 2007.
Grants recognition.
Now, therefore, in exercise of the powers vested under section 14A, 15A of the NCT Act 1993, the NRC, the Northern Regional Committee, hereby grants recognitions to NIOS UP under clause 760 NCT recognition number such for 6 months bridge course ODL mode. So NCT was NIOS directed to conduct because we are recognized, and NCT also in reply to RTI.
Yes.
Number deny.
I take your lordships to the last submission first, that cause of action of the petitioners arose after Supreme Court's order. As I submit, and I find that's probably the writ petition. It's my basic question to myself. Can an interim order passed by any court give rise to a cause of action? One has to satisfy your lordships that I am entitled to an interim order on the principles which is analogously applicable to the writ jurisdiction under Order 39, Rule 1 and 2. These are the salutary principles. Interim order passed by the Honorable Supreme Court always under Article 142. This is not the law binding upon your lordships. This is not the law. So one has to satisfy this Honorable Court that look, I am eligible, I am requiring the fulfill all the criteria under the law. allow me to appear at this. This is the malad should be. Now I take your lordships to this petition first. Now your lordships will find, then oral submissions I will take your lordships. Malad, paragraph 3 and 4. The petitioners have joined a single writ petition for ventilating their common and identical grievances based on the same cause of action raised in the petition. All the writ petitioners are in-service trained candidates having B.Ed degree and 6 months bridge course certificate in professional development program for elementary teachers obtained from National Institute of Open Schooling and TET pass. They are all working as primary teachers in private schools. The PDPT has been recognized by the National Council for Teacher Education, who is the academic body appointed by the central government. Leave aside thereafter. Kindly come to page 4. Your petitioners state all of them have the requisite qualification to be appointed as primary teacher in a state level primary school under the respondent number 1 herein. I take your lordships to that as trial binding, the qualification. Just NCT qualification, your lordships. Just I take your lordships. Right. Page 53.
Yes.
Now your lordships will find secondary education 50% marks, 2-year diploma. Senior secondary with at least 45 marks, 2 years diploma. Senior secondary with at least 50% marks, 4-year Bachelor of Elementary Education. Then senior secondary with at least 50% marks and 2-year diploma in education. At least none of them fulfill that. I do not find any averment, no documents. I will advance my argument on a different point. Why I'm harping on it. One has to show your lordships, look, I am fulfilling this qualification prima facie. Where is that? Now your lordships kindly consider, I get it from one of annexure something, page 54. 54. But from the bottom, latest 5 lines paragraph, recently, your lordships get it. Recently, I have called for a job for interview of West Bengal Board of Primary Education, but not allow my candidature in the verification table of the interview board in time recruitment of primary teacher, not fulfilling 50% marks in graduation level. Although I have 62 number in higher secondary level, I am serving a government recognized private unaided such and such 20. I have a B.Ed degree of 1 year of when NCT approved. Then my lord, admittedly he doesn't have 50% marks. Kindly your lordships. Please. There is no averment. I am searching and getting it. No averment in the petition. That's a different issue. Then my lord, what is then your lordships letter is not applicable?
No, the answer is
kindly allow me to speak. Then you reply. I will go out of the court after making my submissions. My lord, then your lordships go by the paragraph 3 and 4. B.Ed, he doesn't say I'm 50%. No averment. If the B.Ed graduation, unless 50%, he is not qualified, your lordships will be getting it from the next amended application of notification 56 page. Well, kindly see, page 55 was little amended. Notification of NCT. This is 2011, 29 July. All the things are equal. Well, high secondary 50%, senior secondary 45%. The last one, your losses, graduation with 2-year diploma in elementary education. Your loss is getting it. Last one of the column 1, classes 1 to 5. Graduation. Yes, your losses. So one must be graduation, not with B.Ed degree, 2-year diploma. They are all that I get, they are graduation with B.Ed with 6 months. how does he fulfill the qualifications? Prima facie, he doesn't.
So this is the last NCT notification.
Exactly.
2011.
Exactly. No averment that he is a graduate with 2-year diploma in elementary education. Now let us believe your lordship's graduation with B.Ed with 6 months bridge course. How does he qualify himself under the rules? I'm putting a question to myself. No averment regarding the detailed qualifications. If I'm not wrong, in a single writ petition, they have joined, I believe, at least 31 persons. Now, my lord, this is a salutary principle of law, my lord, your lordships has dealt with in civil matters. Prima facie case, irreparable loss of injury, and your lordships, the other three
balance of convenience.
Now, my lord, unless a person, anyone is lacking, one is not entitled to. What is the prima facie case? On the averments. Now, your lordships kindly will look at this jural portion. Because I will be taking your lordships just little on this. This was, my lord, page 27. This was being affirmed by Hiralal Jana.
Yes.
My lord, kindly have a look. One of the writ petitioner affirms it. He has been authorized to affirm. Now, what is the affirmation, your lordships? Kindly see that the statements contained in paragraphs 1 to 4 are true to my knowledge. My lord, there is no supporting documents. No supporting documents. My lord, I put a question to myself. How the writ petitioner number 1 knows about writ petitioner number 2? My lord, one can know on the basis of checking out the documents. Therefore, true to knowledge based on information derived from petitioner number 2. He doesn't take the responsibility of affirming that also. I will show the judgment, your lordships. And why this is being done? Either this was filed just 2 days before because he is fortified by so-called Supreme Court's order, with all respect. I don't know the facts of that also. Interim order. And just 2-3 days before, and moving your lordship is taken up 2-3 days after. He's taking a chance. He has to specifically prove it. My lord, I just tell your lordships to take this point. My lord, in a plaint, one has to, my lord, aver that this is my case. This is the agreement, this is the cause, this is I passed it. But he need not, my lord, give evidence in support of that. Nowadays, my lord, with plaint, annexures are also there, as your lordship knows. But the writ petition, your lordships, each and every line averments, because this is affidavit evidence. Your lordships do not take evidence normally. That has to be supported by the documents. Why I am saying it? Kindly see the submissions. Graduate with B.Ed. So you do not qualify any of the conditions. I will take the Supreme Court's order. Now, TET pass. Where is the certificate? On what basis you TET pass? Orally, my learned friend submitted TET pass in 2014. Then under the relaxation clause. So it differs factually even from the Supreme Court. When the TET qualification he passed, in a relaxation, training was not required for that batch. Then you wanted to qualify your TET on the basis of subsequent 1-year B.Ed with 6 months bridge course. Was it a fact before the Supreme Court? While Supreme Court entertained this in past and interim order, I will take to that your lordships. Now I take your lordships to that interim order.
Mr. Sannal, what happens to the persons who have TET qualification of 2014, 15, 16, all these years?
After I tell your lordships, clarify factually. I get your lordships.
They appeared in TET, they qualified for TET. Now they intend to participate in the recruitment process after the NCTA has fixed a guidelines that you ought to have a DLED course or other training courses as per RCI approved. So what happens to those candidates?
That's a very relevant, pertinent question. Your lordships has seen the guidelines.
Yes.
Now your lordships will kindly NCTA guidelines that your lordships, page guidelines state 69 of your losses.
17.
Yes.
Now let kindly look at page, this is 70, eligibility.
Here.
The following persons shall be eligible for appearing in the TET. A person who has acquired the academic and professional qualifications specified in the NCT notification dated 23rd August 2010. So he has to malad both 50% in higher secondary and 2-year DLED or 4-year DLED, or graduation with 2-year DLED. If your loss is considered 2010 and 2011, both notification of NCT. So he has to qualify. Then your losses. A person who is pursuing the teacher education course, he is also qualified. Now, malad, take example 2. Someone malad sat for TET with the pursuing qualification, but he could not come malad pass out in the malad training qualifications. His TET will go. Simply go. Because you were qualified for this purpose only, even if he passes TET. The third one, my lord, the eligibility condition for appearing in TET may be relaxed in respect of state or union territory which has been granted relaxation under subsection 2 of section 3 of the RTA. The relaxation will be specified in the notification issued by the central government under that submission. Malad, this relaxation was given to the state of West Bengal at that point of time. Malad, with this, that they did not have sufficient training institute. So, Malad, I will advance argument to this extent, which goes in their favor. If you have the TET with, if you have the TET without training qualification under this relaxation clause, you must have DLED, not B.Ed. Clear to your lordships? Because B.Ed has been completely said not a qualification appointment of primary teachers. One cannot subsequent getting a B.Ed. He cannot say, I have passed TET and I am B.Ed, allow me. Because B.Ed was allowed only under the 2018 notification. Malad, that Devesh Sharma's washed it, goes everything.
So DLED is must.
Must. Your losses kindly page 56 and 62 notifications. DLED is the only qualification.
Then
So then he can.
The sir is saying that this prepaid, this
That's 6
prepaid
months bridge course with B.Ed.
but this is equivalent to DLED.
No. Malad, I tell you, lordship, how could I NCT notification has been quashed 2018.
আর ওটা 21 সালের অ্যানসার তারপরে গঙ্গাদি
And after Malad, this is
This notification, this year.
I take your losses. This
2017.
70.
It has not been quashed as yet.
Oh,
It's still in force.
I,
And that is the subject matter pending before the Honorable Supreme Court.
I take your losses. Now, therefore, in exercise of the power vested under such and such, hereby grants recognition to National Institute of Open Schooling, Noida, UP, under such and such, for 6 months PDPT OLED program through such and such, for training of teachers or having B.Ed qualifications, for teaching classes at primary level in government aided, subject to the fulfillment of the conditions mentioned. That's your lordships. This is 2017. Thereafter, they allowed B.Ed itself without malad, forget about malad 6 months bridge course. Complete B.Ed. That was also declared unconstitutional. How can it survive, my lord? It doesn't require. Automatically goes. If the main normal subsequent notification which permitted the B.Ed to be recruited as primary teacher declared to be unconstitutional and quashed by the Supreme Court, how could they be take this benefit? They cannot. And this malad doesn't also amend the notification for laying down the qualifications. Your losses will never find that B.Ed is one of the qualifications. Malad, where are those pleadings in the writ petition that I have got this? This is my qualification. One has to say it. This affidavit evidence. Therefore, malad, everybody is state 14. That government was not there. your lordship will not get it when they pass state. So has to declare it when he did it. Each candidate will differ from the others.
It has not been stated.
Nowhere. I have not found. If stated, my lord, I will stand corrected.
No, chart won't do. Chart will come later on. The averment should be there.
Paragraph 3, that all the, as my London senior friend read out before your lordship, all the writ petitioner are in service, 10 candidates having B.Ed degree and 6 months breach course, certificate in professional development program for elementary.
I am admitting that.
Obtained from NIOS and TET pass.
No, I am admitting that.
6. Kindly come to para 6. Since in very short span of time we have drawn the writ petition, we could not collect all the documents overnight. So your petitioner they need to refer to all their candidates. Qualification certificates at the time of hearing of the instant application if necessary.
So produce it.
Yes.
One after another. Let's see.
Number one document.
Like this, I will do.
But it is
Then
not
losses take it up another day. Let them come back.
Everybody's we are having with in a separate seat.
And private
We have got it subsequently. But it is not the duty and of this honorable court to make it scrutinized. They are the appointing authority. Let them scrutinize. If I do not have, as per the above mismatches, if I do not follow these requisite qualifications, don't allow me. But
this is the submission, my lord. I
don't allow me.
I did deal with this. He's trying to everything, my lord, forced upon me. Now, what is the statement that I have passed state in this year? Which applicant, which year?
Yes.
But this is not that. This is not statement.
For the convenience of this honorable court and also my Latin friend.
How do I deal with this now?
May be treated as a part of the writ petition.
May
not be dealt with. It is for their official purpose. Let them check it. If any documents mismatches with our prepared chart, don't allow me. We are not very innocuous prayer in view of Supreme Court. Passed by Supreme Court SLP in interim as a.
No, I could have understood that within a short span of time you have drafted the writ petition, so it was not possible for you to procure all the documents of the concerned petitioners. But what about you should have specified that in which year petition number such and such has passed the date.
Very well, I'm filing a supplementary affidavit. So
now you will file supplementary again.
It's over. Why should I allow?
Again you will file supplementary. Please, sir.
Admitted date is over.
There has to be some point you have to end that these are my pleadings. Now, once a argument is advanced, now you say that you will file a supplementary affidavit. Now you are posted with all the documents.
I just want, may I sum up my submissions? Your lordship, my learned friend give reply to this.
He have
passed it in 2014.
Okay.
All are 2014. That is my averment in the writ petition.
All have passed
2014. All passed 2014.
But then summer of 2020.
Here averment in para 3.
Where is state 14? How do I know?
Are in service.
Had the court come to know? How?
That is my certificate. Unless right now, so petition number 1 is concerned.
You will come out from your pocket one after another up to 30.
So let it deal with
this is not the way of pleading.
Okay. We consider that they have all passed it. Come on.
Now your lordship, the basic argument I am first making, then I will disavowments. One has to satisfy their graduate. They don't have the 50% marks, admittedly. On the basis of what they have said. I don't know whether my learned friend will jump up, say someone has had 15 high secondary. I don't know. But graduation with B.Ed is not the required qualification. None of the NCT local law.
My humble response.
Please allow me.
That is the subject matter pending before Supreme Court, pending before.
No subject matter pending before the Supreme Court.
Whether these qualifications.
Yes.
This is not the qualification. So this is our notification for recruitment of 25th September. You have not questioned that notification. This is bad because of dependency of the Supreme Court.
We are not questioning this.
So therefore, how do I allow a person?
Sir, will you allow him to submit? Because
how do I allow them?
Much more time. Yes.
Then I cannot, one should not, a recruiting authority. Otherwise, if your losses give this a power to the recruiting authority, that will be, capricious power will be given to the authorities. Why the qualification laid down in the advertisement? So that public should know it and authority must abide by it. This is the law, rule of law. One cannot say that I have this, do this. You have to satisfy this. Okay. Then your lordships, I repeat this, my lord. The pleadings has to be proved by cogent documents. This is the writ petition. Malad, I take your losses just two paragraphs of one paragraph, one judgment. 2009, volume 2 SCC, page 606, paragraph 20. Malad, I am handing up a legible copy because my learned friend is relying upon the malad, amendments paragraph 3, 4, 6, whatever read out. Only paragraph 20. Being conscious of the aforesaid legal position, we are of the considered opinion that the learned industrial tribunal committed a manifest error of law and of fact initially by placing the burden on the employer to prove and establish the job requirements of the said three posts, and thereafter again committed an error in coming to the conclusion that the posts are identical on the basis of the pleadings of the parties alone. Pleadings are required to be proved, and so long evidence is not laid in support of the pleadings, no reliance can be placed only on the pleadings without there being any cogent evidence in support of the pleadings. Pleadings are required to be proved by leading evidence. These principles, salutary principles, applies in the writ jurisdiction. I will show that, your lordships. But whatever my learned friend says, apart from I'm showing to your lordships, they are not qualified on the basis of barred statement in the writ petition itself. This is the first. Now, the kindly take up your lordships the second judgment. 1988, 4 SCC, page 534.
534.
534, paragraph 13. Lord, I just tell your lordships, that was your lordships, the judgment I cited earlier, that is from industrial tribunal. One might say that there was a leading of evidence, that's finding of law. Now kindly see paragraph 13. Now this is being distinguished by the Honorable Supreme Court. Paragraph 13, last 6 lines. While in a pleading, as Lordship got it? While in a pleading, that is a plaint or written statement, the facts and not evidence are required to be pleaded. In a writ petition or in the counter affidavit, not only the facts but also the evidence in proof of such facts have to be pleaded and annexed to it. That's my point, your lordships. And so the point that has been raised before us, before the appellant, is not entertainable. So why, if it, one cannot say hurriedly prepared. Notification 25th September. If you hurriedly prepared, you do it overnight, but properly you have to do it. My first submission, you do not come within the qualification. Second submission, because of this, you cannot urge it even before. The petition should not be entertained. And the third one I'm saying, your lordships, jural portion. Well, in the morning, your lordships seen it. The TET certificate is itself forged. Why should I allow them to come before me when you have come up before this court first? You are saying something pending. You ought to have approached that court then. Why in the separate writ petition? Supreme Court order. But I'm repeating, by of an interim order doesn't create any right. It's settled law. Even passed by the Supreme Court. It doesn't create any legal right. If you are similarly placed, go before the Honorable Supreme Court. Let us fight it out. Because Uttarakhand, what happened, I don't know. They didn't point out that these persons are not at all qualified. I don't know whether those persons, having DLED alternatively or graduation with 50% marks. Even graduation with DLED is not entertainable without DLED. So these are the facts different. Now, another judgment I'm showing you, lordships, that deponent affirmed true to his knowledge of 30 petitioners. He must fix up his responsibility by saying that this is derived from them. Otherwise, this has no sanctity. This affidavit has no sanctity. Well, I'm citing one judgment based on Supreme Court judgment, 2005, volume 1 WBLR, page 848, paragraph 6 onwards. Well, this was, of course, of the Honorable Single Judge Coordinate Bench of this court, but relying upon several judgments of Supreme Court. So I do not burden your lordships to that. Only paragraph 6. Now turning to the writ petition, the preliminary issue is whether the amendments made in paragraph such and such of the writ petition are in compliance with the rules. For brevity, let it be divided in 2 parts. Paragraphs such and such have been verified as true to knowledge, and paragraphs such and such has been verified as matter of records. From the paragraphs which have been verified as true to knowledge, I find no material has been furnished about the source of information. And then the petitioner claims to have been allotted a roll number of the interview, yet the call letter has not been annexed. He says, I have passed state. Which year? Which qualification? He doesn't say so because it's eligibility criteria. In a slipshod manner, you cannot approach the read court. Then, your lordships, though the petitioner asserts that on several occasions he went to the office of the council to know his fate, no date in regard visit has been mentioned. Neither the identity of the person who verbally told the petitioner about the marks obtained by him has been disclosed, not the particular office. Statements made in are vague and cannot be relied upon. I just take your lordship for once again, paragraph 27, page 27. 1 to 4 state malak true to knowledge and those made in up to 9 on the basis of records. Whose records, my lord? And whose knowledge? My learned friend, we know him very much. He doesn't know about my qualification, how much marks I have secured in my examinations, Madhyamik, Uच्च Madhyamik. He doesn't know. He cannot affirm like this affidavit and come before the court just either 2 days before of the recruitment process advertisement date closes or after that immediately. Allow me on the basis of interim. One has to satisfy prima facie case. But this writ petition should not be entertained because of this. These are my humble submissions. Much obliged. I just will come back within 5 minutes again.
Affidavit of service filed on behalf of the petitioner is taken on record.
Before
By the present writ petition, the
so for petitioner number 14 is concerned, he doesn't want to be a party here.
14.
14.
At the very outset, learned advocate for the petitioner submits that the petition number 14 does not intend to proceed with the writ petition. Accordingly, the name of petition number 14 Arnab Nandi is expunged from the array of the petitioners. Para. By the present writ petition, the petitioner seeks for declaring the 6 months professional development program for elementary teachers within bracket PDPET bracket bridge course equivalent to 2 years DLED training course at a semicolon. Declaration that candidate possesses B.Ed qualification and TET pass having 6 months bridge course PDPET certificate issued by NIOS as per guideline of NCT is eligible as primary teachers for classes 1 to 5 and permit the petitioners to fill in the requisite application form as applicable for the recruitment of primary teachers. Notification you have stated? The date of the notification? 25th September 2025. The petitioners contend that all the writ petitioners are in-service trained candidates having B.Ed degree with 6 months breach course certificate in professional development program for elementary teachers, in short PDPET. একটা কাজ করুন না, ওই উপরে যখন পিডিপেটটা বলেছি ওটাই ইন শর্ট করে দিন, ওইখানে এখানে পিডিপেট করুন। Obtained from National Institute of Open School NIOS and TET pass. They are all working as primary teachers in private schools. The PD PATE has been recognized by the National Council of Teacher Education, within bracket NCT, which is an academic body appointed by the central government under the Right of Children to Free and Compulsory Education Act 2009. The petitioner claims that they have requisite qualification to be appointed as primary teachers in the state level primary schools in West Bengal, and therefore they be permitted to participate in the ongoing recruitment process. Initiated video notification number 2367/WBBPE/2025/59R. Oh no, which was the earlier one? Which was the earlier notification? 25th September?
Not earlier. Latest notification is 19th November.
Latest has a earlier one.
Earlier one,
Which was the earlier one?
25th September 2000.
Annexed there because it was not made available. Only subsequent notification was made available.
Bill is in the website. Not
In
available.
all the other writ petitions, this has been. You have a copy of it.
Yes, I have
What
the
is the
copy.
number? Give the number.
Yes,
Number
just I'm giving the number.
Read with
25th
19th November. Read with
25th September.
notification dated 19 November 2025. Mr. Swensol, learned advocate appearing for the petitioners, submits that the petitioners are all qualified in TATE 2014, 2017,
2141 of 25th September
141. ঠিক আছে 2014, 2015, 17, 14, 17, না 15 নেই 2014, 17, 22, এই 14, 17, 2020,
2141 oblique WBBP
with BA degree,
2025 oblique
and they have also
59R
completed 6 months breach course. PD PET they have completed.
Yes,
They have completed PD PET
that's why
course
it's approved.
from the NIOS, ওই National Institute of Open School, ওখানে in short NIOS. The qualification of PD PET has been recognized by the. I have handed over to Mr. Sannal that recognized order
By NCT,
by
NCT,
17 তো এটা
হ্যাঁ।
তারপরে অনেক কিছু চেঞ্জ হয়ে গেছে
NCTE,
the academic authority of the country.
BDA recognition order dated 22nd September 2017. Therefore, the petitioners are eligible to participate in the ongoing recruitment process. He also submits that the Honorable Supreme Court in transfer petition civil diary number 11895 of 2025 has allowed the petitioners before it to appear in the to participate in the selection process. He seeks for similar direction so that the petitioners be allowed by the board to participate in the ongoing recruitment process. On the contrary, Mr. Subir Sannal, learned senior advocate appearing
May I
for
be permitted to
West
interfere?
Bengal Board
He
of,
also relied on the reply to right to information where the
he also
NCT
submits that relying on a reply to the Right to Information Act, he submits that the
The academic authority NCT has given
NCTE has,
page 56.
which is the question to pay
Question number, page 55,
1, 4 and
question
point
number
number
1, 2, 3,
2.
4.
Can in this degree do I
Here primary 1 to 5, question number 2. State examination with the degree and do I eligible for primary teacher? NCT said yes.
This is the 21.
21.
Thereafter,
Yes, that is
22, many water flowed in the Ganges.
Well,
After
that
21.
is the subject matter pending before Supreme Court. Let the Supreme Court decide finally.
relying on a reply to the RTI application of the NCT dated 9th February 2021, he submits that the NCT has replied in affirmation that one can appear in TATE examination with
No.
ছিল
হলো।
তাই জন্যই এটা উত্তর দিয়েছে
Question number 1 is NIOS bridge course
with
graduate along with
PDP PET
is
along
equivalent to
B.Ed qualification.
DPET is equivalent to DLED bridge course. Question number 1 answer was given yes.
Question number 1 answer was not given yes.
No,
Not given yes. Not
question
given
number
yes.
1 referred this notification.
And at that point of time,
As a-
Devesh Sharma was not there 2021. Devesh Sharma was after that. At that point of time, B.Ed was relevant.
Devesh Sharma judgments
Okay.
lordship.
Just a second.
কি বলো?
Not disturb.
And are eligible to be considered for the post of primary school
Lordship.
teachers
Grateful.
within bracket classes 1 to 5. On the contrary, Mr. Suvish Chandra, learned senior advocate appearing for the West Bengal Board of Primary Education, in short WBBPE, submits at the outset that the order passed by the Honorable Supreme Court is an interim order in exercise of its power under Article 142 of the Constitution of India. Such order does not create any right in favor of the present petitioners. The petitioners have not disclosed specifically of their qualifications, and at the same time has not annexed documents in support of such qualification. As per the guidelines of the NCTE, that guidelines page number, Mr. Vishwas?
50,
70.
70. 70.
And 50, that is?
It is 23rd August 20. 53 is 23rd August 2010. The main notification of the NCT.
The 2011 notification?
11 notification is 56. These two notifications are the parent notification.
As per the notifications of the NCTE dated 23rd August 2010 and 29th July 2011, the 2-year diploma in elementary education is mandatory. The petitioners have not challenged the recruitment notification, which also makes the DLED qualification as a requisite qualification. Furthermore, if the writ petition is derived of specific pleadings as well as supportive documents, the court should not entertain the same. In support of his contention, he relies on the decision of Honorable Supreme Court reported past in reported in 2009 volume 2 SCC 606 1988 volume 4 SCC 534. Furthermore, he submits that the affidavit which has been affirmed by petition number 1 in para 2, it is stated that paragraphs number 1 to 4 are true to his knowledge and rest paragraph number 5 to 9 are derived from the records. However, there is no disclosure as to how the petitioner number 1 has the true knowledge of the facts pertaining to the other writ petitioners. No such records / source of information of the deponent has been annexed to the writ petition. Therefore, the statement made by the deponent in the affidavit are not acceptable at all. In support of his contention, he relies on the decision of this court passed in 2005, volume 1, WBLR 848. In light of his aforesaid submissions, he seeks for dismissal of the writ petition. Having heard the learned advocates for respective parties, the only issue which has fallen for consideration is whether the petitioners are eligible to participate in the ongoing recruitment process. Admittedly, the petitioners claim that they are graduates with BA degree and 6 months breach course certificate in PD-PET
And TET qualified.
and TET qualified. In order to examine the aforesaid issue, it would be apposite to reproduce the notifications of NCET. একটা এখান থেকে নেবেন 53 dated 23rd August 2010 and 29 July 2011. এই প্রথম পোর্শনটা নেবেন 1 to 5. After 29 July, no other notification has come
Yes,
up.
subsequently, there are 4-5 amendments took place
When
up to 28th June 2018.
2018.
Yes.
No, these are the parents.
Was quashed. Then 20, yes, it was quashed by Supreme Court in Devesh Sharma.
No, this sort of notification disclosing the qualification, this is 29 July 2011 is the last one.
Last.
Yes. This, acha.
23rd is the parent, Malad, the first one,
And 29 July is the
amendment
The
20.
next.
Okay.
That is the
1
last
to
one.
5. ঠিক আছে?
Which survives.
পেজ বললাম এটা হচ্ছে 56, correct. Para. Mr. When so learned advocate for the petitioners tried to impress upon the court that the chairman NCTE had replied to the reply to the application under Right to Information Act that the petitioners are eligible to be considered for primary teachers. In question number 1, it was inquired, question number 2, in the application, is the NIOS breach course, that is within bracket PDPAT, along with B.Ed is equivalent to 2 years DLED degree? And the answer to the same has been given, that the copy of the order dated 22nd notification 22nd September 2017 issued by NRC to NIOS PDPAT is self-explanatory. Give that notification,
Rashid,
that recognition order.
the recognition of 2017, ma'am. I just now, it's very well. 1 second.
Yes, yes.
দিলাম ফেরত দিচ্ছি।
The penultimate paragraph of the recognition order is reproduced here under. Placed before this court is reproduced here under. It is relevant to note that it does not, in clear terms, say that the 6 months PDPAT program is equivalent to DLED course. There is also no notification amending the eligibility criteria has been issued by the NCTE incorporating the 6 months PDPAT course as equivalent to the DLED course. Therefore, it goes without saying that the record placed before this court does not show that the DLED course, the PDPAT 6 months breach course, that is PDPAT, is equivalent to DLED. The recruitment notification, para 3B, requires the following qualification. Wait, upon 3B টা অন্য একটা বলা আছে আগের গুলো 3B যেটা ফার্স্ট করেছিলাম ওটা 3B কোড করে দিয়েছি। It is not in dispute that the petitioners have not passed DLED course. Thus, the petitioners are ineligible to participate in the ongoing recruitment process. So far as the order passed by the Honorable Supreme Court in transfer petition civil number such and such is concerned, the same does not lay down any proposition. It is relevant to note that the petitioners therein have been allowed to participate subject to the result of the special leave petition. The writ petition para is also bereft of specific pleadings and supportive documents. I am in consonance with this court is in consonance with the submissions of Mr. Sannal and its senior advocate for WPP relying on Aziz Ahmed Supra and Bharat Singh Supra. Dismissed, sir. Sorry.
Great.
My lord, I appear for NCT online, lordship.
Not subject and not
Second, I just to appear online for NCT.
video like clear.
Yes, lordship. Since I'm traveling, I could not go there, lordship.
Okay. Thank you, madam.
Grateful, lordship.
Put up, put up.
এই এটা নিয়ে যাও
Item 3, I appear for the petitioner. But petitioners are 1 mark short of the
Cargo. আমি এটা 15 তারিখে নিয়ে নিয়ে এসছে। Sorry?
সোমবারে করলে খুব অসুবিধা কারণ
Yes.
I don't know. I'm requesting my learned friend to move it on Monday, even at the first time.
at the top, my lord.
Because I tell you, Lordship, my junior has got the brief yesterday evening. We could not prepare ourselves.
Very short
Unless-
point, man. Still, my lord, I won't oppose this on my learned friend's part,
Well,
but
take it on
let
Monday
it
at
be
the very first
taken at the
matter, I
top
don't
matter.
understand.
আপনার কাছে পড়া ম্যান
Monday to
ওরা মেটার না, যে instructions গুলো দেখতে হবে।
Wednesday তে কি আছে? Wednesday.
Then I have to do it today because my lord, from
9th, my lord.
বললাম তো বিপক্ষে বলছি না। Because do not accommodate us, my lord, on Monday. My lord, from Tuesday, second up, I will be out of. So that's
Tuesday second half.
because my flight, I'm telling you, losses at 1:40.
And then second half.
Second up was totally first up. My lord, if you also kindly accommodate us Monday, না রে বাবা।
1 নম্বরের তো ব্যাপার।
আরে নম্বর থেকে 1 নম্বর বলে তোকে সবাই দিয়ে দেবো নাকি? I just little instructions on it.
My lord, actually, my lord, I have filed it within time, and
No,
that is before 9.
আমি নিচ্ছি না, আমার কিছু instructions দাও।
How
My lord, the
how
last,
much before?
last date was 9th. I have filed it before that, and
What is
just
the date?
my lord, date is my lord
9 December was
9th December was the last date, and my lord,
8
date
December.
of affirmation of this writ petition is 8th December 2025.
But I do not take this
It
point.
can't
I
take,
will not.
because just few days before the expert report
Just
was
allow us
uploaded
to
in the
Monday your losses.
website. From there, I came to know, and I applied.
Monday at any time.
Monday.
I will not.
Not
take
on Monday then. Tuesday on first hour.
But then your losses kindly 10:30 because after doing this I will go.
Okay.
তাও আপনি পারবেন না মঙ্গলবার আপনি পারবেন না ফ্লাইট মিস হয়ে যাবে আপনার
কি করি তার
2 PM নিন না, আজকে 2 PM নিন না, 2 PM এর মধ্যে তো ইনস্ট্রাকশন চলে আসবে।
প্রবলেম আছে সব তো বলা যায় না করতে
Then who will Mr.
Monday
discuss?
এত চাপ আপনাদের
এখন তো এই প্রাইমারির এই ম্যাটারই তো চলছে।
There are pension matters are also there. 16th of
I will not take more than 10 to 15 minutes. I think they will.
I will also not take my lord 10.
Give us that liberty.
But he is prepared, my lord, even today. He has done the matter on the previous round of litigation.
That's new.
What new? This is not new. My lord, may I just tell what has happened in the facts?
আমাদের দেখতে হবে, একটু না দেখলে হবে।
কত বাজে? এই না আলোটাকে একটু তুলতে
আমরা আজকে বলি আপনি মঙ্গলবার রিপ্লাই দিয়ে
বা নামাতে হবে ঘড়িটা।
তাহলে সোমবার যে কোনো সময় রিপ্লাই দিয়ে চল।
Accommodation চাইছি।
সোমবারটা আমার
2 PM
সোমবারটা আমি পে করছি না। সোমবার
আজকে করুন না।
তোরা 19 তারিখ থেকে বসে রইলি, 8 তারিখে যে ফাইল করলি।
এক্সপার্ট রিপোর্টটা কবে বেরিয়েছে?
When are you coming back? On 17?
19
19 they are coming to court.
No, man. 20th your losses can take because time is over. If you allow them, I have to accept them. 20th your losses
Let
can
this be
20th কি বার?
না ওইভাবে রেকর্ড
যদি allow করে তখন আবার আপনি বলুন।
এই পয়েন্ট নেব না, তোকে বলে দিচ্ছি।
20th Saturday 22nd এ রেখে দাও।
22 তারিখ
22nd
22nd মানে at the top.
একদম top।
10 সাহেবের নামের উপরে তো নাকি এটা আবার কি আমাদের এগেইনস্ট
না ওটাকে মার্ক করে রাখুন। 22nd এ উপরে দিকে দেবো।
না না আমি ওইভাবে
Item number 4, Lordship, on behalf of the council, I'm praying for not today, Lordship.
মানে
I'm
then
the state respondent.
give some protection. I need it, mal. I tell you, losses why I need it.
Lordship, it's the 2019 matter, Lordship. Somehow,
1909
2009,
2009.
Lordship, somehow the brief has been misplaced, Lordship.
No, what is the name of the petition?
Name of the Apurva Karmakar.
But it's 19.
19 is
9 is 19. Selection was 2009.
yes.
Oh.
Why am I pressing for interim order? In a nutshell, I tell you losses, then I take your losses to the writ petition. I understand. Now, these are 2009 election process. Initially, this was 2009 and 10 jumbled up by the authorities, state government, to all the councils throughout the state. That was quashed by this honorable court. Says no. If you jumbled up both the selection process, certain candidates will lose their opportunity because zone will be horizontal. Now, then 2009 process was segregated and it was started. It was started in 2010. Now, 2010 recruitment process was quashed by the honorable governor on 2014, citing that 2014 or 2012, 2014. Anyhow, year may be wrong little. 2012, by the honorable governor saying that there is malfunctioning the entire selection process. With the direction of the honorable governor that this should be held afresh only amongst the candidates who earlier appeared in 2010. That selection process came concluded. Panel was provisionally approved, but it was kept in the office of the director of the department. This was never published. Some petitioners came up before this honorable court. This was relating to Malda. 4 district, kindly losses, remember Malda, South 24 Parganas, North 24 Parganas, and Howrah. Then first North 24 Parganas candidates came up before this honorable court and said certain facts that it cannot go on like this. They took the point the lifetime of the panel was over 2014. We took the point that how could it be over if you do not publish it? They said from the date of approval. Now it came out before this honorable court. Provisional approval was given in 2014, but this was not published. Court said no, you can't do it. If the provisional approval given, you have to give an effect to that. You can't keep it pending. You didn't publish it. They didn't came to know this year 2019. We succeeded. Now, court goes to this extent because they took the point, the councils, that all the vacancies have been filled up to 2009 by adding to the subsequent recruitment process. Admittedly, that was done, the subsequent recruitment process. These submissions of the respective 4 councils were dealt by the this honorable court, by the honorable single judge, that if necessary, you have to create supernumerary post. Now, supernumerary posts were created. Malad, when the panel was published, those are already empaneled, they were appointed. Now, Malad, the first case came up before this High Court in respect of District of Howrah. At relevant point of times, several persons filed their writ petition. This is also of 2019 because 19 panel was published. Everybody pointed out, look, I have the more marks, but the lesser qualified marks, those who have secured less marks, they have been appointed. But in the meantime, the persons have been appointed. We didn't question into that. Now, in 2021, appointment was made from the panel. Now, this was taken up, all these matters, Malad, in 2024 before this honorable court by the Honorable Mr. Justice Mantha. Now, Malad, I appeared on behalf of the Howrah Council. Now, Malad, I had to concede. I sat with the chairman and had to concede that these are the persons who are, some of them have got higher marks, but you have given the lower marks. They have a Malad submissions. I don't say that they said no logic. They said, because the Honorable Governor says, those who have allowed to appear, those have appeared. If there is discrepancy in the earlier process, I cannot do that. But that cannot, Malad, compromise with the merit. So this Honorable Court, if you do, Mr. Sanal, take instruction. If you do not do this, then I have to quash everything. Now, the Howrah Council came up first with that those who have got the higher marks, they should be given appointment. This court directed those who have soever have come up by a cut-off date of 2023. 9th April 2024. Those who have filed the writ petition and those who have appeared in the in the interview process, the new afresh, they should be appointed. Now, my lord, all the 4 districts, all such persons have been appointed. Unfortunately, this petition is of 2019. This was not tagged for one reason or other because the file was not traceable, all that. Unless the file is all traceable, Justice Mantha refused. Unless file is traceable, you come up. Several other persons, my lord, writ petitions have been disposed of thereafter upon fulfilling those 2 conditions. That 9th April 2024, before that you filed the writ petition questioning the process and you had interview in the de novo process. These are the same candidates. Now, my lord, we have today, out of the vacancy created by way of supernumerary post, certain posts are still lying vacant. Now, if my learned friend goes on taking the point, if those posts are filled up, then I will be in a soup. Because otherwise, my lord, I am a straight jacket case. I have to get relief before your lordships.
But the vacant post, how many vacant posts are there?
No, and I tell you, lordships, here, my lord,
70.
17 writ petitioners there. My lord, already, my lord, 8 persons have got their appointments, only 9. Of those supernumerary posts. I get your lordship the paragraph. I have given
8 of the petitioners have got appointment.
Already got appointment.
Lordship, may I? Lordship, only
No,
Lordship, it is a matter since it was filed in 2019. Only the brief has got misplaced in the meantime. I'm praying only for not today. Lordship may fix it on Monday also, Lordship. We have no issues. Lordship.
Monday, Malad, your lordship already overplaced next Monday. Then, Malad, that's why I'm saying 9 posts out of
and more to that, Lordship, the 17 writ petitioners. I am asking
I'm saying
myself,
not 17.
whether the sufficient court fees has been paid.
And that I will pay, double pay kore debo bhai, chakri ব্যাপার.
What is, you intend to have accommodation for what reason?
Accommodation brief has been misplaced since it's pertaining to 2009.
22nd.
Only for not to.
On 22nd.
All right, I will not.
And in the meantime, if there is no
Sir, kindly record note that I have filed a supplementary affidavit bringing up the subsequent facts.
On the prayer of learned senior advocate appearing for the petitioners.
and Lordship, sufficient court fee may be paid in the meantime.
If I don't
take that,
bhai. তুই sufficient court fees করছিস নাল pay করবো.
On the prayer of learned senior advocate appearing for the petitioners, leave is granted to file supplementary affidavit. Supplementary affidavit filed by the petitioners is taken on record. The earlier orders have been annexed to the.
Yes, all. That's why, my lord, this supplement. Even the Supreme Court has rejected the state plea of the councils.
Council.
It's taken on record, copy served. Learned advocate for the DPSC Howrah.
Malda, Lord.
Malda. Seeks accommodation. This is matter on 22nd.
But only thing, my lord, let it retain its position on Monday, 22nd. That's my only request to your lordship.
Monday to এইভাবেই রাখবে. 22nd, yeah? Hey, Devnath বাবু, যেদিন যেদিন আমাদের মানডেতে ধরো পেনশন ম্যাটার্স আছে, যেদিন মিসেলেনিয়াস থাকছে, মিসেলেনিয়াস 4 হেডিং করেই ওইভাবে রাখবেন। আর ওপরের দিকে রাখবেন মিসেলেনিয়াস। ভেরিফিকেশন হয়ে যাচ্ছে তো, যদি পেনশন না হয় হবে না। মিসেলেনিয়াস ওই ইনক্যাপে যেরকম থাকছে, দুটো তিনটে করে দিচ্ছি, ওই শুধু মিসেলেনিয়াস জন্য দিচ্ছি, ওটা দেখে নিয়ে করো। তারপরে পেনশন যেরকম আছে হুম, ঠিক আছে? Yes.
Item number 5, my lord.
T21 matter নিয়ে কি বলো? What is this?
But I am for the petition.
My lord, in this matter, Mr. Bhaskar Prasad Basu is appearing. Mr. Bhaskar Prasad Basu is appearing on behalf of the council, my lord. Yes, bypass surgery, my lord. I'm paying for 2 weeks' time, my lord.
But it pertains to my lord 2009 selection process, which was initiated by the North 24 Parganas District Management School Council, my lord. Petitioner appeared in the written test, my lord, as well as the interview, my lord.
What is this?
But the writ petition was filed, my lord, in 2021, my lord. The Honorable Coordinate Bench, by the judgment and order dated 25th April 2024, has directed that the candidates who have filed the writ petition up to, my lord, 25th April 2024 will be given appointment, my lord, in connection with the recruitment process of 2009, my lord. But I am praying, my lord, the benefit of this judgment, my lord, passed by the Honorable Coordinate Bench.
It is annexed.
Same number.
But I am told, my lord, identical to item number 4, my lord.
Then
Just now I supply the brief, my lord.
But
what is that?
This writ petition, my lord.
But paragraph,
You are not representing the council at the first instance?
he is appearing for the council. My lord, only, my lord, paragraph 13, my lord, kindly see, my lord. My lord, in the facts and circumstances following the order dated such and such, for the reasons stated therein, in respect of DPSC Howrah, this court by consent of all parties is inclined to direct all the candidates who were called for interview. I was called for interview in the aforesaid recruitment process of the year 2009 and have filed the writ petition until 24th April 2024 shall be entitled to the appointments against existing or future vacancies. But here, my lord, I have filed my writ petition in 2021, my lord.
Now, what was the cutoff date? April 2024.
24th April
It was
2024.
fixed for cut off.
You have filed the writ petition
2021.
and you have appeared in the interview.
I have appeared in the interview.
When he will be joining? Who has undergone surgery? Who will appear for the council?
Well, I am appearing on this for.
No, you are seeking accommodation on
Mr. Boyce is appearing in this matter, my lord. Mr. Bhaskar Prasad Boyce is appearing in this matter, my lord.
Where is he?
My lord, he has bypass surgery, my lord. I'm paying for 2 weeks' time, my lord. I filed a report, my lord. Well, cut-off date was fixed, my lord, by the lordship person order. Just
How many petitioners are there?
One petition.
One petitioner. Check it and then file a report.
Mine.
Yes, my
Only
lord.
2 conditions: whether he appeared in the interview
Mine.
and writ petition
Mine.
filed. We
Great-
can
Grateful.
assess from the record
Great.
section.
Great.
Yes, my lord. I filed a report.
Mr. Swansol, learned advocate appearing for the petitioner submits act. All the candidates.
But one petitioner, my lord.
Huh?
One petitioner, my lord.
No. In WPA 20966 of 2022, along with other writ petitions, were disposed of by this court with the direction that all the candidates paragraph 13, all candidates who were called for interview in the this is recruitment process of
2009, my lord.
in the recruitment process of 2009 and have filed writ petitions until 24th April 2024 shall be entitled to appointments against existing or future vacancies. The petitioner qualify both the conditions as specified in the order of this honorable court. He seeks for extension of benefit, similar benefit in favor of the petitioner. Action. Learned advocate for the Council, this is DPSC Howrah,
North.
North. Advocate for District Primary School Council, 24 Parganas North, seeks accommodation to file report. Let such report be filed on the returnable date. List this matter 1 week after the ensuing winter vacation.
And meantime, they shall verify my credentials. My
No.
File report along with verification of the candidature of the petitioner.
now the petition there.
Next.
Your Lordship, that item number 4, my lord has just now taken up the matter.
22nd.
Yes, my lord, only one thing, my lord, the petitioner has filed a supplementary affidavit that it become infructuous, my lord, and by way of supplementary, there is no leave given at any point of time.
On
But
22nd, you place your argument.
yes,
If
my
it
lord,
is
I have some
infruct-
objection regarding my lord, because a infructuous read by way of supplementary affidavit cannot be revived. My lord, that my objection, I'm just pointing out before your lordship.
I'm not recording today.
Yes.
Because I have passed order.
Yes, my
On
lord.
22nd, you place that it
Yes, my lord, I will argue on the my lord, acceptability of the
Yes,
supplementary. I'm getting.
Item number 6, Lordship, I am for the petition.
For the state respondent.
One of the para teacher. He was joined in service in the year 2010. Thereafter, he continued in his service. All of a sudden, one notice was issued against him regarding the one allegation made, and for that reason, he was not able to join for 3 months. Thereafter, he filed one writ petition before this honorable court. Honorable court pleased to pass an order after giving the 4 days time to the respondent authorities. Thereafter, the ex-party order was passed by the single bench. Thereafter, the order was challenged by the authority before the division bench.
What was the order passed by the single bench?
At page 73, Lordship.
My lord, thereafter, division bench, my lord, on merits, my lord, decided the matter and went up to the Supreme Court. My lord, Supreme Court also goes against the petitioner. Termination of service has been affirmed by the Supreme Court. My lord, I am putting question myself. What is the, my lord, cause of action at present?
Petition, Lordship, I shall submit all the orders before your Lordship. And at page 73, Lordship. May I read the order, Lordship? Page 70.
আরে ডিভিশন বেঞ্চটা দেখান না
সবগুলোই তো উনি তো সিঙ্গেল বেঞ্চ। Page 73 is a single bench order, Lordship. It was on 17th of July 2018.
To rejoin his duties. Okay. The notice of termination was quashed. What was quashed?
It is at page 55.
ডিভিশন বেঞ্চটা কোথায় গেল?
Petition instead of
কত যে রিপিটিশন ফাইল করেছিস মাথা খারাপ হয়ে যাচ্ছে।
Yes.
না দেখলে বার করবি কোথা থেকে?
Yes, sir.
Yes, sir. There 55 was the impugned order at that moment, Lordship. That was
No, no,
challenged
no,
before
no,
the
false.
single bench, Lordship. It is at page 73. If Lordship may please to allow me to, I have to read this single bench order. Then I have to come to this division
My lord,
bench
after the division bench order, my lord, there is no need to relook into the, my lord,
Respondent is so hurried. I shall submit all the services before the court, Lordship.
only, my lord, wastage of time.
Not no wastage of time, Lordship. Otherwise, the matter should not be filed before the court.
So, my lord, then, my lord, I am putting question, my lord, the maintainability of the, my lord, writ petition. What is the cause of action by which petitioner has been compelled to file? Because after termination order had already been affirmed by the Supreme Court, the appeal preferred by the petitioner, my lord, single bench he won. Malad, that was challenged by the Malad before the division by the authority concerned. Malad division bench on merit allowed the appeal and dismissed the writ petition on merit. And against that order, he Malad went up to the Supreme Court. SLP was Malad also dismissed due to Malad
It was
delay.
filed before the international court, Lordship. I am asking only one question before the authorities, Lordship. Kindly, Lordship, consider the page number 182.
এই দেবনাথ বাবু
Page 181. I am asking myself, Lordship, kindly, Lordship, give the reply from them why that type of conduct was done by them, Lordship.
ভালো করতেন এখন দেখছি এছাড়া মিসলেন্সে কিচ্ছু নিয়ে আসবে না কি সিরিয়ালি পড়ে গিয়ে সব 24 21 এর আইটেম আসছে কোনো দরকার নেই এখন ওরা যেটা বললো ওই জন্যই প্রপোজালটা নেবে চলে এমনি এমনি জেনারেল রুল অ্যাপ্লাই করে দিয়েছে এগুলোকে দরকার হলে আলাদা করে দিন এগুলো এখন শোনার সময় নেই Where is the order of the division bench?
Kindly also come to page 181. I shall submit all the submission later on for the reply from them that the why the matter was filed before the court. Kindly also come to page 180. Then I shall come to the division bench order, single bench order, and also the Supreme Court order. There is not a single suppression in this petition. None appeared on behalf of the authority before the Supreme Court. Then also the Supreme Court orders annexed in this petition, Lordship. Kindly also come to page 181.
It is good gesture.
That is the book list, Lordship, 181. It is the dated of 16th of September 2024. Kindly, Lordship, turn the next page, 183. Column number 20. One 183, Lordship. Petitioner name is appearing in the year of 2024, being the Torun Kumar Singh Rai. He was in school. He is still in service. He is doing his job. He being the math teacher. Page 183, column number 20. His name is Torun Kumar Singh Rai. Petitioner name is Torun Kumar Singh Rai. Now, Lordship, may please to come to page 73.
Where is his name?
Torun Kumar Singh Rai, 183, column number 20. Number 20, Lordship, left corner.
Hmm.
17, 18, 19, 20. Torun Kumar Singh Rai. 183. That one is the book list.
And what does it prove? That you are in school?
Yes.
Where is your attendance?
Yes, I'm coming. All of one after one, Lordship. Lordship, please to come to the appeal bench order, division bench order, page 98. It starts from page 98. These are the cause title. Lordship, please to come page 101. I have to read the division bench order entirely. This is necessary before the court. Why the Supreme Court dismissed this SLP? Only because of that order was passed by the division bench. This was the personal grievance. This is an appeal against a judgment and order dated 17th of July 2018, passed by the London single judge of this honorable court on WP number such and such, allowing the writ petition. When this matter was called on last week, Mr. De, the learned advocate appearing for the writ petitioner, respondent number 1, prayed for accommodation, which was granted. Today, when the hearing of the matter started, the court made certain questions to Mr. De about the propriety of the order impugned, as well as how the order impugned in the writ petition was assailed by the writ petitioner. At this, Mr. De not once but thrice prayed for release of the matter by this court so that the writ petition might try his luck before some other bench. We would like to make it clear that we have no special fascination to hear any particular matter, but that does not amount that a matter should be released at the request of the learned advocate merely because he finds a court inconvenient or he bypasses the answer to the queries of the court. I am submitting before your lordship. It was filed by appeal filed by the authority. Question raised by this honorable court upon me, but the answer was not considered. One after one question, I have to try to give the answer. That was avoided. That's why that order was passed by the division bench. One after, kindly, Lordship. It is reflected in his order. We would like to make it clear that we have no special fascination to hear any particular matter, but that does not amount that a matter should be released at the request of the learned advocate merely because he finds a court inconvenient or he bypasses the answers to the queries of the court. If such a procedure is established, it will amount to unmistakably answering in the judgment judicial inquiry of in disposal of the matters by any court or tribunal, irrespective of whichever, whether it is a civil, criminal, writ, or any other matter. The order impugned in the appeal has provided the conclusion first and then some reasons, and we respectfully disagree with the both. The learned single judge has held that on the second occasion, also, the respondent failed to appear despite service. This has been followed by accordingly. I set the respondent ex parte and allow the writ petition in terms of prayer A, B of the writ petition. This was ex parte order. I am asking myself, Lordship. Division may forward this writ petition before the single bench for the further hearing. It was dismissed. That was the first point on which we sought for a clarification from the writ petition respondent number 1 that even if the respondent are absent on successive dates, must the writ petition be allowed on that ground A1. The very crucial connecting word between the two sentences is accordingly. The exercise meaning of the word is consequently. Concise Oxford English Dictionary, EDN 2004, page 8, it inexorably follows from the syllogistic pattern of sentences formation that because of the absence of the respondent, the matter was taken up ex parte and as well allowed. It is settled positions of law that onus of providing a case lies on the petitioner and mere absence of the respondent must not ipso facto tilt the balance in his favor. If that had been the position, all matters which go ex parte should be allowed merely because the respondent are not contesting it. The conclusions of the order impugned is followed by reason which is not sufficient enough for sustaining the same in the appeal. The learned single judge has misread the period of absence of the petitioner from the concerned school as 3.5 months. Only 3.5 months. It should have been about 7 years, and he has picked up one of the grounds mentioned in the order of the district budget officer Sarvashikha Mission Hooghly, that is the appellant herein. In order to appreciate the scope of the writ petition, it was necessary to consider the context in which the order impugned in the writ petition was passed. The petitioner respondent number was an additional para teacher of a certain school in the district of Hooghly. He proceeded on leave without any application, and when he wanted to resume his duties, he was not allowed to join the same. He made a representation to the authorities and filed a writ petition being WP number 592129W of 2006 that the writ petition was disposed of by learned single of this court by directing the concerned respondent to dispose of the representation with a certain period. Pursuant to that, the appellant had given the petitioner an opportunity of being heard and by a detailed and reasoned order disposed of the said representation. The appellant has summarized the initial facts as well as the case of the petitioner sanctity. The undisputed fact that emerged is that the petitioner had been unauthorizedly absent from his duties from July 23rd of 2010 till the date of the order, and he went to join the school in the consent of the managing committee. After recording the undisputed fact, the submissions of the petitioner have been recorded. The petitioner clarified his position that he was absent from his school Due to political pressures of the locality, he was threatened by local people that he would face dire consequences if he came to school. He stopped going to school, but he did not lodge any FIR, thinking that his family would be in a problem due to lack of security. He made an application to the ADI of the school Arambagh in the year of 2011 and made successive applications thereafter till 2012. He admitted that he did not do anything and did not make any attempt to resolve the issue and enjoyed his unauthorized leaves for another 2.5 years. However, the headmasters of the concerned school who joined in the year 2012 supported the case of the petitioner. He submitted that the latter was absent from his school due to the political pressure caused by a false allegation made by a girl student reading in class 5. The appellant rightly discarded this thing, holding that no document had been submitted by the school. What was never mentioned in the representations of the petitioner that there was serious allegation against him of outraging the female modesties of a student of class 5, which had resulted in comments in the school. The petitioner was called at a meeting of the managing committee on July 27, 2010, and guardians had held the petitioner guilty of the charge leveled against him. The petitioner was served with a show cause notice during him and to explain why he should not be given an opportunity to clarify his character. Unfortunately, the whole incident does not find place in the representatives of petitioner. On the contrary, he wanted to pass it of a political conspiracy proceeded by a false allegation. However, he had repeatedly mentioned the situation surrounding the school as dreadful enough justifying his absence. This has been his stand running through the various letters addressed to various authorities. If the situation had really been that serious and if the petitioner had been prevented from entering into the school as sought to be made in the successive representation, it was but natural for him that he should inform to the law enforcing agency. The reason for not doing so, as mentioned by him, that is this security of the members of the family was rightly not found to be a very convenient one by the authority. Regard being had to common experience of ordinary men and their code of conduct, it is difficult to accept that the situation remained dreadful for more than 7 years, that he would not master's courage to inform the police. There is no explanation what he had been doing for all these years. There is equally no explanation why for about 2.5 years he did not even make any representation when he knew that this absence was entirely unauthorized. It appears that the learned single judge had picked up only one reason mentioned by the appellant as the ground for rejections of the petitioner representation. The appellant has also mentioned, with which we are in total agreement, that no regular effort was made by the writ petitioner to join the school during the total period of absence. The interval of long gaps after which these representations have been made are sufficient to suggest discrimination of the petitioner to join the post. And lastly, the allegation against the petitioner had not yet been cleared as well. These three grounds were not considered by the learned single judge at all. On the contrary, he had allowed the petition only on the first ground, that is, non-informing the police authorities about the situation of dating the locality. However, from the whole of it, the petitioner has claimed that he had tried to go to the school only 5 and 6 times during the entire period of absence, and it seems that the petitioner must be deemed to have been reluctant to act as para-teacher. Mr. De feebly tried to justify the order impugned. On the contrary, his grievance was about the unsustainability of the grounds in the memorandum of appeal. Since the validity of the order impugned, the writ petition was under challenge. The onus was entirely upon the petitioner to establish his case. It is the settled positions of law that a plaintiff or a writ petition, as the case may be, must have to stand or raise on the strength of his own case and not the weakness of the defense case. We have perused the writ petition, and there is practically nothing in the justifying the order passed in his favor. The writ petition is constitutionally silent about the kind of composition and disquiet alleged to be existing in the locality by petitioner in his representation. It was necessary that the petitioner ought to have mentioned the same and taken the full responsibility of making such a statement on oath as justifying his decisions not to inform the police authorities about the rowdy situation. Mr. De vehemently relied on the teacher's diary for 3 or 4 days as the proof of his claim that the petitioner has been working in the school concerned, apart from the fact that a photocopy of the teacher's diary unsigned by the school authorities proves nothing. This is also entirely unnecessary. It is quite possible that after the order into the school authorities had allowed him to join his duty. We have already noted the stand of the headmasters of the school at the hearing before the appellant that does not give the petitioner any extra mileage. Mr. De Learned Advocate appearing for the state respondent has submitted that this headmaster must have allowed the petitioner to join without any concurrence of or intimation to either the state authorities of the appellant. For the reason stated above, we find sufficient merit in the appeal and equally lack of it. The order is hereby set aside. The appeal is allowed. The nature of claim made in the petition and the order impugned. We not only allow the appeal but dismiss the writ petition on merit. That is the order of the this is the entire allowable thing was be given, but the original fact was not taken consideration of the that he made several representations before the authorities that was not considered only because of the personal once this was order was passed that was the SLP thereafter the SLP dismissed. I am not on that. Lordship, please to come to page there.
Which page?
Already Lordship most probably considered the page 73 order of the single bench. Yes. Here Lordship, please to come. Page 164.
এই একটা কথা বলবো my lord in this matter my lord the appeal preferred by the my lord state project director Sarvashikha mission Mr. Arjun Rai Mukherjee, it is his appeal. My lord, he is the necessary. It is the necessary party. Sarvashikha mission project director is necessary party to implement. Otherwise, well, he preferred appeal, and that appeal has been decided. But in the writ petition, he has been left out.
It was preferred by
Page 2, the district project officer Sarvashikha mission. Respondent number 2. হ্যাঁ তুই আছিস
Mr. Roy Mukherjee preferred appeal.
district project officer.
Two to district. বলছে district নয়.
তাহলে ওকে
State project director. কত নম্বরে জাজমেন্টটা 101 তো
হ্যাঁ এই তোর নাম আছে
তো 2-3 দিন ধরে পড়বে ও এখন ও ডিস্ট্রিক্ট প্রজেক্ট হ্যাঁ তুমি তো সার্ভিস করিস নি নিশ্চয় কি সুপ্রিম কোর্টে হেরে যাওয়ার পরে কি চাইছে মায়না চাইছে এখন
তুই কি অ্যাপিল করবি
Malad, till now, Malad, I gathered from my learned friend, Malad, he relying upon the Malad division bench. But my initial question is the maintainability of the writ petition. After termination affirmed by the Honorable Supreme Court in 2023, he relied upon Malad, a Malad private document of a school. This is a Malad booklet. These are the teacher and these are the Malad. I am putting question myself. Does it Malad confer any right to the petitioner for reappointment? And if that be so, Malad district project officer is the only authority to issue reappointment. When Malad termination has already been given effect, Malad after that, what is his cause of action?
You're appearing for which?
My lord, this if he is a para teacher, my lord, then my lord, he is working under Paschim Bongo Samogra Shiksha mission. This mission is a my lord is a society, my lord. As I yesterday, my lord, I was telling, my lord, we fund we receive from 60% from the state central government and 40 my lord by the state government. State project director is the highest officer, my lord, under this society. But if it is, if the policy or actions of the Samogra Shiksha mission is involved, my lord, then Pashchim Banga Samagro Shiksha Mission is a necessary part.
So obviously he has paid for arrear of salary and all.
Area of salary.
Yes.
Then my lord, the funds comes from.
No, my lord, he is not praying for area. Termination already been, my lord,
Really?
effected.
Allow the petitioner to attend his duty and release the salary and its arrear.
That is after termination. After termination, he is asking for
Whether
honorarium.
that project director is necessary party in the present writ petition.
My lord, because fund comes from my lord mission, the Sarva Shiksha Mission, PBSSM, Pashchim Banga Samagro Shiksha Mission. They receive the fund and thereafter, my lord, it is distributed amongst all the district project officers.
Okay. To make that party, huh?
Yes, sir.
And the leave of learned advocate for the petitioner, you provide the name.
Yes, sir.
If add go the party respondent, huh?
Learned
advocate for the petition that will serve.
To get better.
And you are representing district project officer.
My lord, the district project officer is under Pashchim Banga Samagro Shiksha Mission.
Okay.
তুমি এর ফাইল করছো তখন নিশ্চয়ই তোমার অথরিটি
সার্ভ করে দেবে সার্ভিস করে দিয়ে চলে আসবে This is matter 2 weeks after the any affidavit direction is necessary.
Yes, my lord. Within a week I can file.
I think my lord, first my lord, maintenance point will serve. Because maintain, yes, state fund also there.
Go through the writ petition, let it be served upon you and then come back whether it is required or not. Let it come back 2 weeks after the winter vacation.
2 weeks after vacation.
কি করেছে 24-25
গৌতম তো 2-3 দিন পড়তো না
আমি বলছি দরকার হলে তো
who is for the petitioner? What is the urgency to take up this? This is fixation or something? Fixation of some pay.
From
12 and 13 তাহলে রাখো. Who is on the other side? 12 and 13. হ্যাঁ ওইগুলো পরে কিন্তু উনি যেগুলো হিয়ারিং করছে ওটার পরে রাখবে চলিয়ে